Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day I earn your subscription. For today's content, we are talking about a recent issue that has come up in Texas. The Texas Attorney General has issued a non-binding opinion that was made at least binding on children's services by an act of the governor. This would require children's services to investigate medical providers and parents who cause their children to undergo certain medical procedures as defined in the relevant regulations or executive order. This has been put in hold in form of a preliminary injunction by a Texas district level judge, which is the lowest level judge that there is, and currently is on appeal. But we're going to cover this in a little bit of depth today because we're going to go back to the Attorney General's opinion and see exactly what it is that they're trying to look into, right? Last time we talked about this issue, we talked about the governor's order. We talked about the governor basically adopting the Attorney General's opinion and directing children's services to investigate medical procedures performed on youth as defined and described in the Attorney General's opinion. The Attorney General's opinion, of course, is one that's saying that this is already illegal. The procedures that are being investigated are already illegal as a matter of state law. And then of course, the governor wanted to investigate that, and that's been put on hold. That's the issue. But we're going to decide all that, and of course, or at least discuss all that. Of course, before actually getting into the merits, I just want to again thank everyone. I'm going to probably do this a couple more times. I just want to thank everyone for their support on my channel. I want to particularly thank everyone in LawTube and everyone who reached out on Twitter to help put pressure on Team YouTube to help resolve this issue. I believe it in no small part helped the issue to be resolved faster, that people were able to put pressure on them. And I want to thank Team YouTube for ultimately doing the right thing. The damage to my channel is not too bad. I've lost maybe 1,000 subs, and I've lost at least tentatively, I'm not sure if it's permanent or not, a couple hundred videos. And the videos that are present are currently in a very, very jumbled order. But the most important thing that we got back is the channel itself. Even if we lost all the content on the channel, which is not ideal, we would still have the subscriber base and the platform and brand that I've worked very hard to develop. So I just want to thank everyone very much. So even if we don't get back our videos, and even if it becomes a disaster area in terms of the videos, in terms of their organization, we ultimately got back the most important thing. And I want to thank Team YouTube for doing the right thing. We praise when things go well. And that is something that, it was not a particularly fun 36 hours or so of my life, but, and it's still ongoing to some degree, but we press on. Let's move to the content for today. So as I sort of indicated, we're going to go over the Attorney General's opinion letter, and we're going to try to see exactly what it is that the Attorney General thinks is already illegal. And I think this is important because people who have covered this seem to be under the impression that what is being investigated is any time a transgender youth is taken to a doctor by their parent, or any sort of counseling relating to transgender, or any sort of education relating to transgender. And there's been some suggestion that this is much broader than I think it is. And this is not the first time we've seen this happen recently. There was the whole Florida Don't Say Gay bill, which never said don't say gay. In fact, the entire bill never used the word gay. What it was attempting to do was preventing K through third graders from being taught about transgender stuff in classrooms. It wasn't preventing them from being taught by parents, or wasn't preventing anyone from saying gay. It was attempting to determine what should be taught to the K through third graders in the public schools, and maybe less with some transgender stuff, which we've definitely seen books and we've discussed on this channel relating. So whether or not you think that's a good thing or not, it isn't the Don't Say Gay bill. It never was. So it's important to remember what these things are and what they're not. So let's discuss Texas's thing and what it is and is not. So we're going to go back to the letter from the Attorney General, because that is where this party started This is a letter from the Attorney General Ken Paxton of Texas, and he is issuing a letter to Representative Kraus, who is the House Committee, the chair of the House Committee with respect to general investigations. So as chair of this committee, he has asked the Attorney General for an opinion letter, and the Attorney General has written back an opinion letter, like, what is the state of the law? And the Attorney General says, here's my view of the state of the law. Great. The question presented, whether certain medical procedures performed on children constitutes child abuse. Procedures. Dear Representative Kraus, you have asked whether the performance of certain medical and chemical procedures on children, several of which have the effect of sterilization, constitute child abuse. You specifically asked about procedures falling under the broader category of gender reassignment surgeries. You state that such procedures typically are performed to transition individuals with gender dysphoria to their desired gender, and you identify the following specific sex change procedures. 1. Sterilization through castration, vasectomy, hysterectomy, ophthalmectomy, medicamoplasty, orthectomy, petectomy, phalloplasty, and vaginoplasty. I only know what some of those things are. The things that I know what they are not perhaps to be recommended for children. Mastectomies and removing from children otherwise healthy or non-diseased body parts or tissues. Okay, so we want to know whether or not certain medical procedures, including the removal of healthy body parts in the children, might constitute child abuse. This is the question we want to present. Is this a child abusive thing to do these things? Okay, let's read on. Additionally, you ask whether providing, administering, prescribing, or dispensing drugs to children that induce transient or permanent infertility constitute child abuse. You indicate the following categories of drugs: puberty suppression or puberty blocking drugs, superphysiological doses of testosterone to females. This would be giving biological females more testosterone than their body would otherwise require, and superphysiological dosages of estrogens in males. Same, like giving them more testosterone or more estrogen than their body would otherwise require, with an idea in mind of the gender transition therapy or gender affirming therapy that they call it. I do like the euphemism of gender affirming therapy, because left-leaning people seem to have a very different idea of what gender affirming therapy would look like. So I do like the same word can mean two very, very different things to do two different groups of people. What I think is gender affirming therapy and what other people seem to think is gender affirming therapy look very, very different, I assure you. So when we say gender affirming, what do we mean is always a helpful thing to be. But this is the thing we want to ask. Hey, can we do the sterilizations? Can we do the hysterectomies? Can we do the vasectomies? Can we do the puberty blocking drugs? Is that an okay thing for us to do? These are questions that we'd like to have asked. Okay, let's ask that question. You qualify your question with the following statement. Some children have medically verifiable genetic disorders of sex development or do not have normal sex chromosome structures for male or female as determined by a physician through genetic testing that require procedures similar to those described as requested. In other words, in rare circumstances, some of the procedures you list out are born out of medical necessity. For example, a minor male with testicular cancer may require an orthrectomy, which I'm guessing from context means removal of the testicles. This opinion does not address or apply to medical necessary procedures. Fair enough, right? So some of these procedures may be medically necessary, and some of them may not. So it is possible for a child under the age of 18 to get cancer. as we all too well know, right? And it may be medically necessary to have various body parts removed or various glands removed. And some of these might be ovaries or testicles, for example. This is not ideal. But then again, cancer is a bastard, right? So yes, it may be required in some circumstances to have some of these procedures done for truly medically necessary things. We're not attempting to discuss that right now, right? That is not the scope of this letter. We're not trying to discuss, hey, what about the under 18 male with the testicular cancer? What if we want to remove the testicles as part of the treatment of the testicular cancer? We're not trying to answer that question right now. We're trying to answer the question for the, how about just because they believe in some sense in their mind they are a different gender to which their body would suggest. Can we do it for that reason? Whatever it might be true of medically necessary reasons. Great, let's press on. All right, based on the analysis herein, each of the sex change procedures and treatments enumerated above, when performed on children, can legally constitute child abuse under several provisions of Chapter 261 of the Family Code, right? So the Attorney General is now going to, back up his opinion with, legal analysis. That's a good place to start. These procedures and treatment can cause mental or emotional injury to a child that result in observable and material impairment of a child's growth, development, or psychological functioning. These procedures and treatments can cause or permit the child to be in a situation in which the child sustains a mental or emotional injury that results in observable and material impairment in the child's growth, development, or psychological functioning. These procedures and treatments can cause physical injury that results in substantial harm to a child. These procedures and treatments often involve a failure to make a reasonable effort to prevent an action by another person that results in physical injury that results in substantial harm to the child, particularly by parents, counselors, and physicians. In addition to analysis under the Family Code, we discuss below the fundamental right to procreation, issues of physical and emotional harm associated with these procedures and treatments, consent law in Texas and throughout the country, and existing child abuse standards. Each of the procedures and treatments you ask about can constitute child abuse when performed on minor children. So this is, of course, an analysis of the currently existing law. The Attorney General cannot make new law. The Attorney General does not have the power to make new law. The Attorney General is the chief law enforcement officer of the jurisdiction. In this case, it's the Attorney General of Texas, which makes him the chief law enforcement officer of Texas. That's his job, right? He's the chief law enforcement officer. And he is going to promulgate an opinion as to what he thinks the law says, the law that already exists. And he's going to show his work. And we can agree or disagree with his work, right? We can look at his work and we can say the degree to which, hey, Attorney General, you seem to be off point here, right? That's a possibility we need to consider. The Attorney General could be wrong. The Attorney General has been wrong before, of Texas, of the United States, of whatever. The Attorney General sometimes is full of shit. And sometimes the governor or the president is full of shit, right? Through their executive orders. We can do that. We can analyze this and we can say, hey, wait a second, Attorney General. So what you're saying really makes sense? Or are you trying to sneak something through the back door, as it were? Are you trying to make law rather than just enforce law? So we can put on our legal education hats and we can answer these questions together. How good is the Attorney General's case for it being a problem under the current existing law? Now, if the Attorney General wants to recommend new laws, he can, of course, recommend new laws, because anyone can recommend new laws, right? If he at some point in this letter says, it just is not a ban under the current law, but I really think it should be, maybe we should do that, right? He can do that. He can offer an opinion as to what he thinks the law should be, as long as he's willing to distinguish it from what the law is, right? What is and what ought to be are, as always, two very distinct propositions. So as long as he's keeping that distinction clear, fine. But if he tries to blur the line between is and ought, then we, as good legal educators, should, scorn him accordingly. So as long as he's trying to describe what is, we want to make sure that he's not trying to sneak through the back door what ought. And let's keep these distinctions firm in our minds. Great. Let's read more. Forming the basis for your request, you contend, and of course, all this, is strongly influenced by the question asked. The question asked is probably the most important thing in law, in my opinion. Other people might disagree, but the question you ask very much drives the answer. So we could also potentially fault the question, but we should also pay attention to the degree to which the Attorney General is actually answering the question. So we could also analyze this from a position of maybe the question's crap, which is also a possibility. But does the Attorney General do a good job in answering it? These are all different frames of reference we can consider as we're putting our thinking hats on, as I think we should do. Great. Forming the basis of your request, you contend that sex change procedures and treatments you ask about are typically performed to transition individuals with gender dysphoria to their gender desire. Now, note the way this is phrased. He's saying that the procedures are normally done for that reason. He's not saying the procedures are normal. He's saying that when the nature of the question is, the nature of the contention is, when these procedures are done, they're normally done for this reason, as opposed to another reason. And we've discussed a potential other reason. Cancer treatment in some situations. But the normal reason that this would be performed is for the sex change procedures relating to gender dysphoria. The novel trend of providing these elective sex changes to minors, and it is a bit of a novel trend, whatever you might think about it, this is pretty new. All things considered, this wasn't a thing, 20 years ago. It wasn't really even a thing 10 years ago, so it is a bit novel. The novel trend of providing these elective sex changes to minors often has the effect of permanently sterilizing these minor children. Often. How frequently often is questionable, I guess, but when you refer to these procedures as sex changes, it's important to note that it remains medically impossible to truly change the sex of an individual because this is determined biologically at conception. Fair. No doctor can replace a fully functioning male sex organ with a fully functioning female sex organ or vice versa. In reality, these sex change procedures seek to destroy a fully functioning sex organ. That's the predicate, by the way. In the case of the gender dysphoria, the organ itself is functioning properly. So they seek to destroy a fully functioning sex organ in order to cosmetically create the illusion of sex change. I mean, that is definitely one way to conceive of what's going on here, right? You are taking something that works for its function, it does what it's supposed to do, and you are destroying it in favor of a cosmetic, which the cosmetic replacement doesn't do the thing that it looks to do. It does not function as that thing. So, and a true sex change procedure is impossible because sex is determined at birth. You are XX or XY, and if you fall into any other category, this memo is not attempting to deal with that right now. So, let's press on. Beyond the obvious harm of permanently sterilizing a child, these procedures and treatments can cause side effects and harms beyond permanent infertility, including serious mental health effects, venous thrombosis or thromboembolism, increased risk of cardiovascular disease, weight gain, decreased libido, which makes sense. If you're destroying the sex organs, probably has some effect on libido, hypertriglycemia, elevated blood pressure, decreased glucose tolerance, gallbladder disease, benign pituitary paroxysma, lowered and elevated triglycerides, increased homocysteine levels, hepatotoxicity, polycythemia, sleep apnea, insulin resistance, chronic pelvic pain, and increased cancer and stroke risk. And in order to justify all that, by the way, there is a footnote which says, see Tim Cavanaugh, MD, cross-sex hormone therapy from Fenway Health, LGBTQIA, healtheducation.org, /WP-content/upload/cross-sex hormone therapy 1. So apparently to an article, the Attorney General says, according to an article that can be located on LGBTQIA healtheducation.org, these are some of the risks that may instill from the sex-changing procedures. While the spike in these procedures is a relatively recent development, and that for sure is true, sterilization of minors and other vulnerable populations without clear consent is not a new phenomenon and has an unsettling history. True enough. Historically weaponized against minorities, sterilization procedures have harmed many vulnerable populations, such as African Americans, female minors, the disabled, and others. Yeah, if we're going to start talking about the sterilization for the undesirables, there's a bit of an uncomfortable history of that in the United States. I would love to direct your attention at this point to Skinner versus Oklahoma and Buck v. Bell as two examples from the United States Supreme Court of this horror show. What sterilization of the undesirable, you say, uncivil law? Well, let me tell you a little bit about Buck v. Bell and Skinner versus Oklahoma and some other decisions of the U.S. Supreme Court in the early 20th century. When eugenics was used not as a dirty word. There's a bit of uncomfortable history there. Pressing on. These violations have been found to infringe upon the fundamental human right to procreate. Any discussion of sterilization procedures in the context of minor children must, accordingly, consider a fundamental right that's at stake, the right to procreate. Given the uniquely vulnerable nature of children and the clear dangers of sterilizations demonstrated throughout history, it's important to emphasize the crux of the question you present today. Whether facilitating parents, counselors, or conducting doctors, medical procedures and treatments that could permanently deprive minor children of their constitutional right to procreate or impair their ability to procreate before those children have legal capacity to consent to those procedures and treatments constitutes child abuse. This is the question that they're trying to answer. And I think that to some degree, this question has been obfuscated by some other people that are covering this topic. This therapy may be good in some circumstances. I'm not going to come out here and try to make a global claim, because what have we talked about in law many times? If you use words like always and never, you're probably going to have a bad time. Words like always and never are to be avoided, because always and never is rarely correct. So we can't make universal claims that to say it never is good or never is beneficial. But then again, when we're creating policy relating to medical care, we have to think about the norm. If we wanted to say that, if we wanted to allow every medical procedure that could, in some circumstance, be beneficial, then there would be basically no limits on medical procedures. Maybe you think that's a good thing. Maybe you think there should be fundamentally no limits on medical procedures. Maybe you think a parent with the agreement of the doctor should be able to conduct any medical procedure that they agree upon. Or maybe you think that's a bad plan, and there should be some limits. And then this question just becomes like, what kind of limits and where should they be? For the purposes of our immediate question, we're trying to ask the question, let me make sure to put this on screen so we get this exactly right. Whether facilitating or conducting procedures and treatments that could permanently deprive minor children of their constitutional right to procreate or impair their ability to procreate before they have legal capacity to consent constitutes child abuse. With all due respect to some of my friends on the progressive side of the aisle, I think that this is a perfectly reasonable question. And I think that to the extent this is happening, it could be a problem. Now you might say to me, uncivil law, this doesn't happen to minors. There aren't minors who undergo permanent procedures that could impact their lives. And to that, I would say I'm not so sure. In response to a recent request from another YouTube creator for authoritative sources about these procedures being conducted on minors, I recently tweeted 3 articles that are scholarly that seem to suggest that some of these procedures do in fact occur on those under 18, even if they're not supposed to under U.S. law. And also, to the extent that you're saying it never occurs, if your argument it never occurs to children, then you shouldn't be upset about us banning it because it never occurs, right? So if it's truly the case that no child in the United States undergoes a permanent procedure that could impact their fertility, if that never happens, great. Let's ban it, because we're banning nothing. Then we'll be happy, the right will be happy, because we'll have banned something that makes us feel better, and the left will lose nothing in exchange, right? Because we'll have banned nothing. So we'll get this meaningless moral win that at least will make us feel better, and the left is no worse for wear. So let's come together and ban the nothing. You know, we will have accomplished nothing on the right, and the left can mock us for, you know, the accomplishment of the nothing. And we will have banned something that never happens, and everyone will be happy because it never happens. How about that? Let's ban the thing that never happens. That sounds like a good idea. Let's ban the thing that never happens, and we all agree should never happen, so there's no problem with banning it. Fantastic. The medical evidence does not demonstrate that children and adolescents benefit from engaging in these irreversible sterilization procedures. To my friends on the left who say that, hey, the children are never subject to irreversible sterilization procedures, great. If it never happens, can we please ban it? Can we please ban the thing that never happens, since, hey, it never happens, so you guys are losing nothing. We come away with a moral win that has absolutely no real-world impact. Everyone wins. It's great. The prevalence of gender dysphoria in children and adolescents has never been estimated, and there's no scientific consensus these sterilization procedures and treatments ever serve to benefit minor children dealing with the gender dysphoria. As stated by the Centers for Medicare and Medicaid Services, there is not enough high-quality evidence to determine whether gender reassignment surgery improves the health outcomes for Medicare beneficiaries with gender dysphoria, and whether patients most likely to benefit from those surgeries can be identified prospectively. Also, several studies show a higher rate of regret at being sterilized among young women than among those who were sterilized at a later age. This further indicates that minor children are not sufficiently mature to make informed decisions about this context. This is a problem, right? It's like, should a child be allowed to undergo this procedure with their consent, assuming their parent and doctor also consents? Can a child consent? Well, a child might not be able to fully understand the ramifications because it might have permanent impacts. And my friends on the left say it never has permanent impacts. Great. Can we ban the things that have permanent impacts, since those are nothing? And then everyone wins, right? We will only, I promise, my Scouts honor, we will only ban the things that have potential permanent impacts on the children. And then, you know, that will be nothing. We'll only ban the things that have potential permanent impacts. That will be nothing. And then the progressives can have all the transgender therapy they want because it will have no permanent impact, and everyone's happy. Let's do that. I'm a bridge builder over here in Uncivil Law. I'm a bridge builder because I can achieve consensus between the right and left, right? We'll ban the nothing, and you'll continue to do all the things you could before, and everyone's happy. There's no evidence in the long-term mental health outcomes are improved or the rates of suicide are reduced by hormonal or surgical intervention. Childhood onset gender dysphoria has been shown to have a high rate of natural resolution, with 61 to 98% of children re-identifying with their biological sex during puberty. This is all a quote, by the way. No studies have ever been to date have ever evaluated the natural course and rate of gender dysphoria resolution among the novel cohort presenting with adolescent onset gender dysphoria. So the prospect that 61 to 98% of children re-identify with their biological sex during puberty comes from the Society for Evidence-Based Gender Medicine, which can be found at segm.org. One of the few relevant studies monitored transition individuals for 30 years. It found high rates of post-transition self-harm and significantly elevated all-cause death, including increased death risk from cardiovascular death, disease, and cancer, although causality could not be established. Fair enough. Correlation is not causation. All-cause mortality has increased. We're not sure why, but we'll take a note of it. The lack of evidence in this field is why Centers for Medicare and Medicaid Services rejected a nationwide coverage mandate for adult gender transition therapy during the Obama administration. Similarly, the World Professional Association for Transgender Health states, with respect to irreversible procedures, genital surgery should not be carried out until patients reach a legal age of majority to give consent of procedures. My friends on the progressives left tell me that none of these procedures ever happen to minors. Great, let's continue banning it. And also, if it's already banned, so this is where my friends and I on the left are going to have a bit of a breakdown on the logic. All right, let's apply this logic. All right, let's apply logic and reason to this situation. All right, my friends on the left and my friends on the progressives say, among other things, that no minors undergo gender surgery. Okay. They say that no minors undergo gender surgery because it's already illegal. Okay. It's already illegal. Okay. So the Attorney General reaching the opinion it's already illegal would be the exact same opinion the progressives have. And the left has. It's the exact same opinion, right? So Ken Paxton may be a right-wing SOB. Perhaps he is a right-wing SOB, but the left says, and the progressives say, it is illegal under current law. They say, the lefts and progressives say, no minors undergo the gender surgery. They say that no minors undergo the gender surgery because it's already illegal for anyone under the age of 18. The Attorney General of Texas says it's illegal for anyone under the age of 18. The Attorney General of Texas says this is a problem. The governor of Texas directs Children's Services to look at anyone who was undergoing the procedures that the Attorney General says is illegal, and also the left and progressives say is illegal. Let's investigate anyone who does the illegal procedures that the left say are illegal. Question, why is this a problem? Why is this bad? Why is it a problem for the governor of Texas to issue an executive order to the Children's Services to investigate any procedures the Attorney General says are illegal and also the progressives say are illegal and also never happen? Why is it a problem to investigate things that everyone agrees is illegal? Anyone have any thoughts on any of that? Anyone have any thoughts on why it's bad for the governor to direct the Children's Services to investigate the procedures that everyone apparently agrees are illegal? Anyone have any ideas? Moving on. Generally, the age of majority is 18 in Texas. With respect to consent to sterilization procedures, Medicare sets the age threshold even higher at 21. Children and adolescents are promised relief and asked to consent to life-altering, irreversible treatment and do so in the midst of reported psychological distress when they cannot weigh long-term risks the way adults do, and when they are considered by the state in most regards to be without legal capacity to consent, contract, vote, or otherwise. Legal and ethical scholars have suggested it's particularly unethical to radically intervene in normal physical development of a child to affirm a gender identity that is at odds with bodily sex. This premise comes from, because there's a citation, comes from Ryan T. Anderson and Robert P. George. Physical interventions on bodies of children to affirm their gender identity violate sound medical ethics and should be prohibited. Published in Public Discourse, the Journal of the Witherspoon Institute, which is available online. State and federal governments have wide discretion to pass legislation in areas where there's medical and scientific uncertainty. Thus, states routinely regulate the profession of medicine and routinely update regulations as new trends arise and new evidence becomes available. True. In the opioid context, for instance, states responded to an epidemic largely created by pharmaceutical companies and medical professionals, dismissing as opioid phobic any concerns that raised to pain treatments a patient's right to issue could lead to over-reliance on experts. These experts created new pain standards and assured doctors that prescribing more opiates was largely risk-free. So apparently during the opioid boom, people who said, hey, maybe not so much with the opioids, were actually labeled opioid phobic. This proposition, by the way, also has a footnote. This proposition comes from David W. Baker, the Joint Commission on Pain Standards, Origins and Evolutions. So, as we now know, these risks were indeed are nothing short of tragic. There's always the potential for novel medical determination to promote promoted remedies that may not improve patient outcomes and can even result in tragic harms. The same potential for harm exists for minors who have engaged in these types of procedures or treatments above. The state's power is arguably at its zenith when it comes to protecting children. In the Supreme Court words, this is due to particular vulnerability of children. The Supreme Court has explained that a children's inability to make critical decisions in an informed, mature manner makes legislation to protect them particularly appropriate. The procedures that you ask about impose significant and irreversible effects on children, and we therefore address them with extreme caution, mindful of a state's duty to protect children. Children, by definition, are not assumed to have capacity to take care of themselves. They are assumed to be subject to the control of their parents, and if parental control falters, the state must play its part as parent parente. In this respect, the child's liberty interest may, in appropriate circumstances, be subordinated to the state's parent parente interest in preserving and promoting the welfare of children. So, the child's interest in liberty may be subsumed by other authority because they are not necessarily in the decision to make the decisions for themselves. So, to the extent these procedures and treatments could result in sterilization, they would deprive the children of fundamental right to procreate, which supports a finding of child abuse under the Family Code. Subsection A, the procedures you describe can and do cause sterilization. The surgical and chemical procedures you ask about can and do cause sterilization. Citing Philip Chang, Fertility Concerns of Transgender Patients. Similarly, the treatments you ask about often involve puberty-blocking medications. Such medications suppress the body's production of estrogen or testosterone to prevent puberty, and are being used in this context. In this context, they're being used, because they could be used for other reasons that wouldn't present a problem, but in this context, they're being used to pause the sexual development of a person that occurs during puberty. The use of these chemicals for this purpose is not approved by the FDA and is considered an off-label use of that medication. The chemical procedures prevent a person's body from developing the capability to procreate. There is insufficient medical evidence available to demonstrate that this discontinuing it resumes a normal puberty process. See generally Hennessy Walker v. Snyder, Bell versus Tazvock, and Portman NHS Trust. And this also refers to Bell's conclusion that a clinic's practice of prescribing puberty-suppressing medication to individuals under the age of 18 with gender dysphoria and determining such treatment was experimental. Thus, because the procedures you inquire about can and do result in sterilization, they implicate a minor's child's ability to procreate. So yes, it is not clear that you can necessarily give these puberty-blocking drugs and merely stop it and everything will return back to normal, which is an argument from my friends on the left and the progressives. It may be true in some circumstances that you can do this for free, as it were. It may be true in some circumstances that you can prescribe these medications, and it is possible in some circumstances that it may result in no long-term harm. I don't know. I'm not a doctor. And also, just to say always or never is not always. To say always or never is usually problematic. So it may be true that in some situations you can do this for free. It will cause the patient no long-term harm. Also, it may be true not so much with these experimental off-label uses on the children who cannot necessarily consent. So the data seems a little bit questionable. The United States Constitution protects a fundamental right to procreation. The United States Supreme Court recognizes a right to procreate is a fundamental right under the 14th Amendment. See Skinner v. Oklahoma. Almost a century ago, the Supreme Court explained the unique concerns sterilization poses respecting this fundamental right. The power to sterilize, if exercised, may have subtle, far-reaching, and devastating effects. In evil or reckless hands, it can cause races or types which are incidental to the dominant group to wither and disappear. There's no redemption for the individual who the law touches. Any experiment with the state conducts is to his irreparable injury. He's forever deprived of basic liberty. Yeah, they said that and then went on to approve of the sterilization. It's Skinner versus Oklahoma. They said, yeah, it would lead to all these really negative things, and then said the negative things would be totally fine. Skinner v. Oklahoma was not, Oliver Wendell Holmes' best moment. To the extent procedures you describe cause permanent damage to reproductive organs and functions of a child before they have the ability to consent, they unlawfully violate the child's constitutional right to procreate. Sounds about right. Under Texas law, a minor is a person under 18 years of age that has never been married and never been declared an adult by the court. State law recognizes 7 instances in which a minor can consent to certain types of medical treatment on their own. None of the express provisions relating to a minor's ability to consent to medical treatment addresses consent for procedures using for gender-affirming treatment. Again, by gender-affirming treatment, my friends on the left and I have very, very different ideas of what gender-affirming treatment would look like. It's a wonderful little it's a wonderfully elastic euphemism. Who would be opposed to gender-affirming treatment? It affirms gender. Why would you oppose that? Because you have a very different understanding of what gender affirming is than I do. The lack of authority of a minor to consent to irreversible sterilization procedures is consistent with other law. The federal Medicare program does not allow for parental consent, has established a minimum age of 21 for consent to sterilization procedures, and imposes detailed requirements for obtaining that consent. Federal Medicare funds may not be used for any sterilization without complying with consent requirements, meaning a doctor may not be reimbursed for sterilization procedures performed on minors, or as it happens, anyone under the age of 21. The higher age limit for sterilization procedures was implemented due to a number of special concerns, including historical instances of forced sterilization. Minors and other incompetents have been sterilized with federal funds, and an indefinite number of poor people have been improperly coerced into accepting sterilization operation under threats that various federally supported welfare benefits would be withdrawn unless they submitted to the irreversible sterilization. Citing Ralph versus Weinberger. In addition, the 21-year minimum age of consent rule accounted for concerns that minors were more susceptible to coercion than those over the age of 21, and younger women had higher rates of regret for sterilization than those were sterilized at older ages. Regarding parental consent, Texas law generally recognizes a parent's right to consent to a child's medical care. But this general right to consent to certain medically necessary procedures does not extend to elective, which they define as not medically necessary procedures, and treatment that infringes upon a child's constitutional right to procreate. Indeed, courts have analyzed the imposition of unnecessary medical procedures upon children in similar circumstances in the past to determine doing so whether constitutes medical abuse. One such situation law has addressed is what's often referred to as Munchausen's by proxy, or fastidious disorder imposed on another. Quote, a psychological disorder that's characterized by intentionally feigning, exaggerating, or induction of symptoms of a disease or injury in oneself or another, and is accompanied by seeking excessive medical care from various doctors and medical facilities, typically resulting in multiple diagnostic tests, treatments, procedures, and hospitalizations. Unlike the malinger, who consciously induces symptoms to obtain something of value, the patient with a fastidious disorder consciously produces symptoms for unconscious reasons, without identifiable gain. In such situations as this, an individual intentionally seeks to procure, often by deceptive means such as exaggeration, unnecessary medical procedures or treatments either for themselves or others, usually children. In Texas, courts have found Munchausen by proxy situations can constitute child abuse, which, In the context of elective sex change procedures for minors, the legislature has not provided any avenue for parental consent, and no judicial avenue exists for the child to proceed with these procedures and treatments without parental consent. By comparison, Texas law respecting abortion requires parental consent and, in extenuating circumstances, permits non-parental consent for minors to obtain abortions. But the Texas legislature has not decided to make those same allowance for consent to sterilization, and thus a parent cannot consent to sterilization procedures or treatment that result in permanent deprivation of a minor's constitutional right to procreate. Thus, no avenue for a child to consent to obtain the procedure that caused sterilization. Again, I'd like to remind my friends on the left, to the extent they say the procedures that would cause sterilization are never done on minors and are already illegal. They are already in consent. They're already in agreement with the Attorney General, and so I begin to wonder what the problem is. I mean, if procedures that cause sterilization in minors, if elective procedures that cause sterilization in minors are already child abuse or already illegal, then I'm not sure where the left and Ken Paxton are disagreeing, to be honest. Maybe they think those procedures don't cause sterilization, but they're experimental and off-label and novel, and being administered at way higher numbers. So in the face of uncertainty, the state's role becomes more prominent. We discussed this to some degree when we were discussing mandates related to COVID. In the face of uncertainty, the state's role grows, doesn't shrink. So if things are experimental, if they're unknown, if the medical risk profile is not clear, the state's role becomes more. This is completely consistent with my analysis for COVID, for example. I said, and people were very unhappy on my channel when I said in the early days of COVID that the relative mandates that were in place at that time were illegal. I'm talking like the first 3 months of COVID. And if my channel ever becomes organized again by date, you can go rewatch my old content where I said that. And people on my side of the aisle were very, very grumpy with me for saying that. But I'm like, look, guys, it's basic propositions of law. The state's role in medicine is notable. It's strong. The state's interest in health and safety is strong. It's a strong interest. The state's ability to do like quarantines and stuff is well established at law, as deep as you want to go. And in the face of uncertainty, with unknown threat of unknown vectors and unknown threat profile, state level governments, although not necessarily the federal government, except when it comes to immigration issues. So to the extent you're trying to prevent people from coming into the country, the federal government would have more power on this issue. To the extent you're trying to regulate people already within the country, you're looking to state level authority. And I pointed out in the early days of COVID, in the first 2-3 months of COVID, I'm like, and people were complaining to me about a lot of these regulations. And my analysis, to the chagrin of my own chat and my own people, was, well, a lot of these are probably legal. That remains my opinion as to stuff in the first 2-3 months of COVID. It's still my opinion. My opinion hasn't changed. You know what did change? The facts changed. The facts changed. The unknown became less unknown. The threat profile changed. The facts changed. And law, of course, is facts sensitive. So when the facts changed, the legal analysis changes, not because the law changed, because the facts changed. Different facts produce different legal result. Whoa, film at 11, right? So, like, if you asked me then, and you ask me now, hey, are those government regulations in the first 2-3 months of COVID legal? I'm like, yeah, probably. Probably. Is that to say everything they did in the first 2-3 months of COVID was legal? No, of course not. That'd be equally dumb, because you just use the word like every. And we know what we said about always and never, right? Does that mean every regulation they did? No, because what did we say about always and never, children? It's to be rarely applied, right? So of course not. We're not saying always and never. But yeah, probably in large part, yeah. And then how about after the first 2-3 months? Well, when the facts become a lot more well-known and the threat profile becomes a lot more well-known and we realize it's not the Black Death, hey, maybe not so much with those justifications anymore. They don't make sense anymore. And then you start seeing, like, things getting struck down by courts. And I'm like, yep, right analysis. Because the facts changed. Right? So state level governments have more power in the face of medical uncertainty. Great. Okay, so that's the proposition I want to stand for. And I want to show how this proposition can be consistently applied, right? And how I'm trying to be consistent in my application, right? This was a proposition that at the time hurt my side of the aisle. Right? In the early days of COVID, it hurt my side of the aisle. It hurt the people watching my channel. It hurt the people who want to say, maximum liberty, maximum all things. I'm like, guys, I can't give you any answer other than what the law requires. I mean, the answer is, in the face of uncertainty, the power of the state, blah, blah, blah. I mean, I'll give you the analysis, right? And it's like, dun, 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 dun. It's just consistent application of law. If it hurts the side of the right, that's the way it has to be. And then applying the standards consistently, which of course I do, I'm like, well, okay, the Attorney General says that this is off-label. He says that these are novel procedures. He says that these are uncertain procedures with uncertain long-term outcomes. I'm like, yeah, that sounds right to me. He also says it has a really ugly history, which I know to be true from reading cases like Skinner and reading cases like Buck versus Bell. I know it has a very ugly history. And there's a lot of medical uncertainty here. I'm like, yeah, there's a lot of medical uncertainty here. So what would that imply? Well, that would imply the power of the state grows. That would imply, especially as it relates to children in particular, who have even less ability to consent. So yeah, the idea that the government, in the face of the medical uncertainty with these potentially life-changing sterilization-inducing procedures, in the face of uncertainty and confusion, would want to take a stronger role and strike down those procedures in the face of medical uncertainty, the left should be thrilled. The left should be thrilled. This is the exact same power they were using when they wanted to ramp up things with COVID. It's the exact same damn analysis. It's the power of the state coming in to override people's decisions. It's the power of the state coming in with the full force of the power of the state and the full force of police power to crack down on individual liberty. They loved it when it was the COVID, and I gave them the analysis when it was the COVID in the first 2-3 months. I'm like, you guys are right. You know, police power, government power, cracking down, individual liberty. Let's do the analysis. No problem. Bang, bang, bang. The left should be thrilled. Look how powerful the government is, guys. Look what they're doing in the face of the medical uncertainty with the children, the particularly vulnerable, in the face of an ugly history. And they're like, hey, you know, we should be really, really concerned about this ugly history. And these people are particularly vulnerable who are getting these potentially these life-changing things that have long-term impacts in long-term, and 60 to 98% of them change their mind and doesn't seem to have any impact. And it doesn't seem to change the mental health rates. And there's all this, you know, all this problem is the power of the state overriding individual liberty. Where's my friends on the left at? This is what you wanted. This is the same analysis. Why aren't you happy? It's the same analysis. You got exactly what you wanted. Why are you unhappy? And this question, Blue-Footed Pig, does Kurt think trans is contagious? No, Kurt does not think trans is contagious. If what you came away with in that entire analysis, if what you came away with was Kurt thinks trans is contagious, I respectfully submit you weren't paying attention. What a way to reduce everything I was saying, man. So you're saying that it's contagious? No, I'm not saying it's contagious. Let's try this again. I'm saying that it's producing long-term impacts on patients who are particularly vulnerable and don't have the ability to consent, that has unclear long-term impacts, creating medical uncertainty. Most people, to the overwhelming majority, to almost universally, change their mind, producing unclear long-term impacts that include sterilization. And in the face of all this uncertainty, the power of the state grows in the exact same way. The fact that it's contagious or not is not particularly relevant. It's the state taking concern about medical uncertainty and using its traditional regulatory power, police power, to regulate the practice of medicine, particularly with respect to vulnerable populations when there's so much uncertainty, and the power of the state grows. If what you came away with in that analysis is that Uncivil Law is saying he thinks the trans is spreading like a virus, I don't know what to tell you. Think harder. Man, what a way to reduce everything I said to something that, this is just Kathy Newman. So what you're saying is, no, I'm not saying anything even remotely close to that. Wow. Wow. Moving on. Having established the legal and cultural context of this opinion request, we now consider whether these procedures and treatments qualify as child abuse under the Family Code. Whether, as a factual matter, one of these procedures or treatments cannot result in sterilization, a court would have to go through the process of evaluating on a case-by-case basis whether the procedure violates any procedures of the Family Code, and whether the procedure or treatment poses a similar threat or likelihood of substantial physical and emotional harm. Thus, where a factual scenario involving non-medically gender-based procedures or treatments of a minor causes or threatens to cause harm or irreparable injury to a child, comparable to instances of Munchausen syndrome by proxy, or criminal injury to a child, or demonstrates lack of consent, a court could find such procedures to constitute child abuse under the relevant law. Family Code Chapter 261 provides for reporting and investigation of abuse or neglect of a child. Of course, this broad definition of abuse would apply to and includes criminal acts against children, such as female genital mutilation or injury to a child. Yeah, female genital mutilation has been banned in the United States for quite a long time, but apparently it's okay for some people in their view when it comes to the trans thing, which is very, very uncomfortable. Your questions implicate several components of section of the relevant law. The relevant law identifies mental or emotional injury to a child that results in observable and material impairment in the child's growth, development, or psychological functioning. The relevant law provides that causing or permitting the child to be in a situation in which a child sustains a mental or emotional injury that results in observable and material impairment on the child's growth, development, or psychological functioning is abuse. The relevant law includes as abuse physical injury that results in substantial harm to a child or a genuine threat of substantial harm from physical injury to a child. And the law includes failure to make reasonable efforts to prevent an action by another that results in physical injury that results in harm to a child. Offering some clarity to the scope of abuse under the relevant law, the Texas Department of Family and Protective Services adopts rules giving meaning to key terms and phrases used in the definition. The department acknowledges the emotional abuse is a subset of abuse that includes mental or emotional injury to a child that results in observable or material impairment to a child's growth, development, or psychological functioning. The department rules provide that mental or emotional injury means that a child of any age experiences significant or serious negative effects on intellectual or psychological development or functioning, and exhibits behaviors indicative of observable and material impairment, meaning discernible and substantial damage or deterioration to a child's emotional, social, and cognitive development. I'll take a bit of a break here and see where the state of the chat was just for a moment. Someone wanted to know the exact title of the thing from the other day. Let me see if I can find that information for you. I don't know if I can give you the full title. Yes, I can. So this was the full title of the video. If I say the title, does that get me in trouble with the YouTubes? I don't even know what the rules are on this. Can I say the full title without getting in trouble? I honestly don't know. Maybe I shouldn't say the full title. Maybe I'll just make some up words that, yeah. So the full title was $25 billion. These words don't count in this sentence. Ethereum locked up. These words don't count in this sentence. Parentheses, Ethereum 2.0. These words don't count in this sentence. Ethereum price prediction 2022. These words don't count in this sentence. And Ethereum news today. These words don't count in this sentence. That was the title of it. Yeah. So there you go. And just for the sake of the YouTubes, I have no particular position on any cryptocurrency. I'm not educated enough to have a opinion on any cryptocurrency. I definitely do not endorse any particular cryptocurrency. And to the extent I have an opinion at this particular moment, it's somewhat negative when it comes to cryptocurrency for fairly obvious reasons. This is definitely not financial advice in any sense. Do your own due diligence. Pressing on. With respect to physical injuries, the department further clarified the meaning of the phrase physical injury that results in substantial harm to the child, explaining that it means in relevant part, real and significant physical injury or damage to a child that includes, but is not limited to, any of the following: if caused by action of an alleged perpetrator directed towards an alleged victim, impairment of or injury of any bodily organ or function. The department rules also define a genuine threat of substantial harm for physical injury to include declaring or exhibiting the intent of determination to inflict real and significant physical injury or damage to a child. The declaration or exhibition does not require any physical contact or injury. The relevant law in these rules define abuse broadly to include mental or emotional injury in addition to physical injury. To the extent these procedures about which you ask may cause mental or emotional injury or physical injury, they constitute abuse. Further, the legislature has explicitly defined female genital mutilation and made such act a felony. While the legislature has not elsewhere defined the phrase genital mutilation, nor specifically for males of any age, the legislature's criminalization of that particular kind of genital mutilation supports an argument that analogous procedures that include genital mutilation, potentially including gender reassignment surgeries, could constitute abuse under the relevant law. Thus, many other procedures and treatments you ask about can constitute female genital mutilation, which is a standalone criminal act. But even where those procedures and treatments may not constitute female genital mutilation under the relevant law, a court could still find these procedures and treatment constitute child abuse under a different section of the law. The Texas Family Code is clear. Causing or permitting substantial harm to a child. Also, going back to our earlier discussion, although I don't know why I'm making this point about whether transgenders is contagious, is transgenderism contagious? I will take note that the rates of gender dysphoria have gone up quite a lot. Apparently, recently, it was announced that the rate for females, minors in the UK, has gone up 4,000%. It's my understanding that there has been similar rates in the United States of growth when it relates to gender dysphoria. It is also true that psychological phenomena can, in general, be transmissible. This is particularly notable, for example, in particularly notable self-harm incidents. It is generally noted that when there's particular notes of self-harm by children, copycat syndrome can be a real problem, to the point where many schools will go kind of out of their way not to talk about it, which I don't know if necessarily is a good thing in balance, but yes, psychological phenomena can be infectious. It is notable that psychological phenomena can spread like a virus, and that yes, it can be contagious. So to go to your question of is transgenderism contagious, to say no may not actually be completely correct. It is quite possible that in many, if not most instances, that this is a psychological contagion that is equivalent to other kinds of psychological contagions. So yeah, to say it's contagious, to some degree, yes. Now that we want to actually analyze this question, even though I wasn't saying that, but if I were, like, that's not the reason that the analysis did what it did. I did the analysis for other reasons, but if you want to go to, is transgenderism contagious? Psychological phenomena can be contagious. So, possibly. The Texas Family Code is clear. Causing or permitting substantial harm to a child or child's growth or development is abuse. Courts have held that unnecessary surgical procedures that removes a healthy body part from a child can constitute a real and significant injury or damage to the child. The Williamson case involved a victim of medical child abuse, sometimes referred to as Munchausen system by proxy. Munchausen system syndrome by proxy is where an alleged perpetrator attempts to gain medical procedures and issues for their child, or presumably other dependent, for secondary gain for themselves. As a result, the children, or other dependent, is subjected to multiple diagnostic tests, therapeutic procedures, sometimes opera procedures, in order to treat things that aren't really there. The evidence shows that 2 surgeries performed on a child were not medically necessary, and that a mother knowingly and intentionally caused unnecessary procedures to be performed by fabricating, exaggerating, or inducing symptoms that led to surgeries. Similarly, in Austin v. State, a court of appeals upheld a conviction for felony injury of a child of a mother suffering from Munchausen syndrome by proxy, who injected her son with insulin. In guidance documents published for Child Protective Service attorneys, the Texas Department of Family and Protective Services explained Munchausen by proxy syndrome is relatively rare, but where it does occur is frequently a basis for finding of child abuse. So yeah, where it does occur, it would be a basis for finding abuse, because yeah. Whether motivated by Munchausen syndrome by proxy or otherwise, it's clear that unnecessary medical treatment inflicting on a child by a parent can constitute child abuse under the family code. By definition, procedures and treatments resulting in sterilization cause physical injury that results in substantial harm to a child, or a genuine threat of substantial harm from physical injury to a child. By surgically altering key physical body parts of children in ways that render entire body parts, organs, and entire reproductive systems of children physically incapable of functioning. Thus, such procedures and treatments can constitute child abuse under the relevant law. Even where procedure treatment does not involve physical removal or alteration of the organs, that is, puberty blockers, these procedures and treatments can cause mental or emotional injury to a child and results in observable and material impairment of a child's growth, development, or physiological functioning by subjecting a child to mental and emotional injury associated with lifelong sterilization and impairment to one's growth and development. Therefore, a court could find these procedures and treatments to be abuse under the relevant law. Further, attempts by a parent to consent to these procedures and treatments on behalf of their children may, if successful, cause or permit the child to be in a situation where the child sustains a mental or emotional injury that results in an observable and material impairment in the child's growth, development, or psychological functioning, and could be abuse under the relevant law. Additionally, the failure to stop a doctor or other parent from conducting these treatments and procedures on a mild child can constitute failure to make reasonable effort to prevent an action by another person that results in physical injury that could result in substantial harm to a child, and failure to make a reasonable effort to prevent can also constitute abuse under the relevant law. Any person that conducts or facilitates these procedures could be engaging in child abuse, whether they be parents, doctors, counselors, or otherwise. And I will also note, to the extent that my friends on the left and the progressives noted that this is a problem because it might cause a doctor to break confidentiality. First of all, that isn't a HIPAA problem, probably, because HIPAA doesn't apply to where there's legal requirements to disclose, right? So HIPAA is the federal law, the Health Insurance Patient Portability Act, and it doesn't apply to instances in which disclosure is otherwise required by law. And every state has requirements by law to disclose for actual child abuse. Child abuse is already something doctors have to disclose. So to the extent that my friends on the left are saying, well, this would violate a doctor's ethics, I don't see it. It wouldn't violate it any more than they're already having to be violated by reporting child abuse. It's just what the state is considering child abuse, which the doctor may or may not in their own head consider child abuse, right? So a doctor or physician or a nurse is required to disclose certain things, even if they don't think those things are child abuse. And I can't speak to every doctor in the state of Texas, but it's quite possible that we as society, and even people on the left, would agree things are abusive, but the doctor may not subjectively think that. And the doctor can't complain about the fact that it violates their ethics. They have a duty to disclose anyway, right? Maybe they think it's not that big a deal and they shouldn't disclose, but that's not the law. So, I mean, that's not a new problem. If you think that's a problem for doctors to have to violate their oath to disclose, if you're against doctors being mandatory reporters, fine, but, you have to universalize that principle. I one of the philosophers I really like is Immanuel Kant, because I don't think he's right in the extreme, but I think he's more right as a guiding tool. And so Immanuel Kant talks about categorical imperatives. Categoricals are things that are always true or never true. And so if you're going to do things, you should try to think in categorical ways. So it's like, okay, is it okay for a doctor to violate their oath? If you want to say never, fine. But, you have to apply that consistently. It's a way of doing consistent thinking. And if you want to have exceptions to that, fine, but you have to think it through. You have to think it through consistently if you want to be consistent, which I, as always, never to do. So, it's important to note that anyone who has reasonable cause to believe a child's physical or mental health or welfare has been adversely affected by abuse or neglect by any person shall immediately report this, as defined in the Family Code. Further, if a professional has reasonable cause to believe a child has been abused or neglected, or may be abused or neglected, or a child has been a victim of an offense under the relevant law, and the professional has reason to believe the child has been abused as defined by relevant law, the professional shall make a report not later than 48 hours after the hours professionals first had reasonable cause to believe a child has been the victim of abuse. This term includes teachers, nurses, doctors, daycare employees, employees of clinic or healthcare facilities that provide reproductive services, juvenile probation officers, and juvenile detention officers or correction officers. Failure to report these circumstances is a criminal offense. And so, yeah, that is the opinion of the Attorney General with relation to this. And so, to my mind at least, I don't find this too wrong. I mean, we could quibble with it in parts. We're not going to say it's perfect. We could quibble with it to be sure, but it sounds more right than not. It sounds fundamentally correct. And you can disagree with the premise that there are procedures that cause these issues, but the Attorney General believes that it does, and believes that the data is uncertain, and believes that it's novel, and believes that the scientific consent for off-label and non-FDA approved uses and stuff like that, and there's problems and lots of regret and issues like that, and he believes that there's cause to support that it's child abuse under the current law. His argument seems fairly reasonable, all things to my mind. Now, in terms of where this goes from here, the Texas District Court, well, we'll read the district court's opinion because it was so bad. Well, it's so unsatisfactory. So they issued an injunction. They issued a preliminary injunction on Friday, and I have not been able to find a copy of this thing. So I don't know what's going on in terms of this, but we can read the judge's TRO. So we'll read the judge's TRO on this thing for all the value it has, which is not much, unfortunately. So we start with just the basics of who the parties are. Here's the parties. From the facts set forth in the petition declarations attached, the court finds the plaintiff will suffer irreparable injury unless defendants are immediately restrained from enforcing it. The court finds that Jane Doe has been placed on administrative leave at work and has risked losing her job, and that Jane Doe works for Department of Children's Services, has been put on leave because they want their own child to undergo therapy that's in violation of the law. The court finds they've been placed on administrative leave and risk losing her job, and Jane, John, and Mary Doe face imminent and ongoing deprivation of constitutional rights, potential loss of necessary medical care. No, they don't. And stigma attached to being subject of unfounded child abuse investigation. Feels kind of founded to me. Court finds that if placed on child abuse registry, Jane Doe could lose the ability to practice profession. If she's engaged in child abuse, yeah. They could face a civil suit by patients for failing to treat them in accordance with professional standards, and loss of licensure for failing to follow her professional ethics. And therefore, it's ordered that it's a very, very, and that these cannot be remedied by money. So it's a very wanting analysis. It's very superficial. It's certainly not as detailed as the Attorney General's opinion was, right? It's very superficial. So the TRO was appealed to the Court of Appeals, which denied the appeal, apparently on the basis that TROs cannot be appealed, which, okay. TROs apparently can't be appealed, I guess. Yeah. And so now it's been made an injunction, a preliminary injunction, which I believe can be appealed. So the Court of Appeals, which bounced it on procedural grounds before, well, they won't have the same concern, I don't think, because I'm pretty sure those can be appealed. So I don't know, man. This feels very thin. I would imagine the Court of Appeals is going to reverse, but we'll see. We'll see. So that is all the things there. And that's all the things there. We could also go pull the relevant HIPAA law just to talk about HIPAA. I'm not going to put it on screen, but I'll read it to you. Read the relevant provisions. Let's see. So the Office of Civil Rights is looking into whether or not the state level regulations are in violation of civil rights law under the Affordable Care Act, because it's on the basis of sexual orientation or gender identity. What do they say about they can file a complaint with the OCR, Office of Civil Rights. HIPAA limits circumstances in which healthcare providers may disclose information. Providers who are concerned about it should seek legal guidance. OCR reminds covered entities and business that HIPAA permits but does not require disclosure. So HIPAA doesn't require it, but it permits it. So HIPAA permits but does not require covered entities, which are doctors in this situation. HIPAA permits disclosure about an individual without authorization when such disclosure is required by law and disclosure complies with the requirements. This is limited to mandates contained in law that compels an entity to make or use disclosure that's enforceable in law. So HIPAA allows it but doesn't require it. But since it allows it, if a state says you must, then HIPAA may not require it, but the state can require it because HIPAA permits it, so it's not a conflict with federal law. So it's fine. Under HIPAA, the Department of Justice is still investigating it for whether or not the state law would violate Obamacare or otherwise be discriminatory on the basis of sex, which is of course a different issue, but it's not a HIPAA problem. Those are all the things. So we'll continue covering it. We'll continue covering it because it's an interesting issue, and we'll see what happens as it progresses throughout the system. But this has been fun. So I think we'll sign off for now. I think we've got everything covered and have sufficiently covered the issues and did a pretty thorough legal analysis. Thanks to the super chat for $25. Appreciate the super chats that came in today. As always, they always help the channel grow and all the rest of it. Remember to tell your friends to like, comment, and subscribe. Many of them may have been unsubscribed, so please remember to tell people like, comment, subscribe, help the channel to grow. Would really particularly appreciate it in this particular instance, and we'll go from there. But this seems plausible. So I'm gonna sign off for now. Remember to do all the YouTubey things. We'll be on later. Until later, my friends, I hope all is well. Cheers and goodbye.